good morning, everyone, and welcome to this edition with Coffee with Joe. I'm Joe Osamendi, your host, but you know that that's not the most important thing. Most important thing are the three people I have sitting to my right here. And you know, I'll tell you something. I'm not an attorney. I don't even play one on TV, but I invite them on my show. So then they're going to talk about something I think is very important for everybody to understand, which is going to be workers' compensation, and we're going to talk about personal injury and disability and Social Security is going to come in, right? So we're going to put all this together today in this segment of Coffee with Joe. And really, welcome to the show. I really love to have you guys back.
Thanks for having us.
Good to see you.
Yeah, good to see you again.
Adam and Justin and Liz, good to have you. You know, one thing about workman's compensation, I want to start off with that, okay?
Sure.
There's a lot of, as I was telling you, Justin, before the show, my layman's definition is the fact that, I think that it's an employee being able to get medical things taken care of, compensation for work, and in lieu not suing the employer. Is that correct?
Sure. Yeah, when you boil it down to its simplest form, somebody who's injured in the course and scope of their employment is entitled to have their medical benefits paid,
Right.
to have their lost wage benefits paid if they're out of work for a certain period of time, usually at least 7 days.
Right.
And at the end of the case, if they suffered some sort of permanent loss, they're entitled to financial compensation for that. So when you boil it down, that's really what, from a macro level, what the workers' compensation is. And you're right, it's not a lawsuit against your employer. It's actually a claim that you file with the New Jersey Department of Labor. And this system was set up because if every employee who got hurt in the course and scope of their employment was suing their employer,
Right.
no employer would ever be able to have any employees because, right, their insurance premiums would be through the roof, right? So this system was set up as kind of a nice middle ground there.
Okay. One of the reasons I wanted to do this show today is because many people think that workman's comp involves unions and big companies and stuff like that, but that's not necessarily true, because now we have people working out of their homes. We have people that are independent contractors, all that kind of thing, and I think that's one of the things I'd like to address today. You and I were talking about a little bit at the beginning. What happens if I'm working out of my house, all right?
Right.
And all of a sudden I go out and I slip on my own threshold when I'm picking up a letter that my employer wants me to look at.
Sure.
Right? Who's responsible? Can I file a claim against him?
So I would argue that you absolutely can file a claim, no question about it. And the question is the respondent or the defense attorneys, the attorneys and the insurance companies representing the employer, are they going to fight us on that? Perhaps. But I would argue that as long as you're in the course and scope of your employment, and that's boundless, you could be on an international business trip, right? You could be at your home, working from home, right? During COVID, a lot of things changed. A lot of people started working remotely, so their home became their office. So I would argue certainly that this is a viable claim because you were injured while working. It doesn't have to be within the confines of your actual employer's building or facility if they have one. As long as you're injured in the course and scope of your employment, we would argue, and I think I could speak for him too, that this is a compensable claim. And to take it a step further, Joe, we had a case come in recently, if I may,
Please.
and it was from a friend of mine's mother who's a nurse, and she was asked to come to a holiday party for this particular big medical provider. And while she was at this holiday party, and she was walking to go to the bar, and of course, as you know, we can empathize with, right?
Yes, sure.
And she tripped on a little crack in the dance floor, and she broke her femur. And
Big injury.
It's a big injury, and she didn't think to file a workman's compensation case because she's thinking, hey, I'm at this holiday party. I'm not acting as an RN treating patients or anything like that. But I told her, this is absolutely a workers' compensation case. You were asked to come to this party by your provider, by your employer. Your employer is getting a benefit because she's been around a long time and she was doing her schmoozing with the people that were there that her employer wanted her to. And this was a clear benefit to the employer. So I told her, our position would be you absolutely have a viable workers' compensation case. So there really is no physical limitation to a workers' compensation case.
Okay. What about people like Lyft drivers and stuff like that? Because that's something that more people are getting into, right? Lyft and Uber and stuff like that. Are they covered under workman's compensation?
Good question.
That's a really good one.
Yeah, it's a good question.
You know, the gig economy and the changes in our social dynamic with these independent contractors who are not really independent contractors is a really hot topic in New Jersey right now. In fact, the Department of Labor is currently litigating this issue with several different large-scale employers who misclassify people that work for them as quote-unquote independent contractors. So when we take the extension of some of that litigation that's ongoing right now, and the Attorney General for the state of New Jersey is actually spearheading the majority of that litigation, and we take that overlay into the workers' compensation court, we've got a lot of really great arguments. Although they're not a W-2 employee, so the taxes aren't being taken out, they don't report to a traditional job setting, much like you were talking about before with the client who works, maybe working at home, or your friend's mom who's at a facility, a bar facility.
Right.
Yeah, it depends what you're all about, right? All for work. And we take that to Lyft or Uber or Uber Eats or DoorDash or any of these different gig economy vendors, and we look at a question of what makes sense. Are they economically dependent upon the employer to make a living? Does the employer control what they do, where they go, how it is that they make a living? And when we look at the long-standing social policies for workers' compensation benefits, the answer is going to be, in my view, and maybe I'm a little aggressive and maybe I'm a little bit pro-petitioner, they're entitled to the benefits. They're giving up the right to sue the employer in civil court. They're giving up those open-ended damages. And so the social legislation around workers' compensation, where we try to include as many people as is possible under the law, and we try to give as much benefits to the injured worker as possible, this says there should be workers' comp benefits. And I'm in the middle of litigating this right now. This is another friend of a friend of yours who's in the office, and she suffered a really significant motor vehicle accident at work. And our hearts feel for her. I mean, she can't do what she was able to do. She's not able to hang out with her children the way that she was and should be able to. She's not able to work. And the insurance company for this one company, and I'm not going to say which of those, you may have mentioned one of their names, they're taking the position of, oh, no, you don't work for us, you just, work for us, right? You don't work for us, you just drive our people around whenever we tell you to. You don't work for us, we just pay you. You don't work for us, you just submitted an application with us. You don't work for us, but we tell you all the things that you have to do and you can't do. Well, if it looks like, feels like, sounds like, and smells like, you don't pick it up to make sure it is.
Right.
So we're litigating that right now. And so far as I know, and I've done a lot of research around this, nowhere in the state of New Jersey has there been a definitive ruling that these gig workers, whether they be Uber, Lyft, Uber Eats, DoorDash, or any of the other ones, nowhere I'm aware of has a determination been that they are formally an employee or formally not an employee. Now, what generally happens so far, and maybe I might be the one to not do this, is the parties just agree to a compromise, the client gets some money, the insurance company for the vendor or the respondent, they don't have a decision made, and everybody goes away. Except it doesn't always work that way. We believe in compromise, we believe in resolution for many of our clients, but sometimes people need their day in court. And what we do at Kotlar, Hernandez Cohen is we fight for that day in court. And if there's an issue that's important to our client, we're going to stand by, we're going to fight it, and we're going to get to a decision. So keep posted on this one. We'll let you know soon.
And see, I have another question about that too. Take the Uber or Lyft person. When is it determined whether they're actually working or not? Because are you picking up a fare? Are you finished a fare? How do you determine it?
Man, that's a good
The
question.
answer is yes, and yes. Yeah. So it's really interesting because Uber and Lyft as a rideshare company are subject to another set of regulations that the state of New Jersey passed for specifically around ride-sharing entities.
Okay.
And there's a difference for them. When they're on the clock, meaning they're available for a call, they have one set of insurance protocols available to them under the civil litigation laws. When they are on the way to a call being dispatched, there's another set of insurance coverage available. And when they physically have a rider in their vehicle, there's a third set or third tier of insurance. So when I look at this as both a civil trial attorney as well as a workers' compensation law attorney, I look at this and I pull the analogy out of the civil trial world where this state of New Jersey, who regulates these rideshare companies, have said once you are available, meaning you're on their network, ready for dispatch, ready to get a ride, well, to me, you're furthering an employer benefit. You're making yourself available, And that access to coverage for the consumers of Uber or Lyft or Uber Eats or whatever the company may be, well, there's an employer-driven benefit. So as I take the analogy of what the state of New Jersey, the legislative intent behind it, saying that the government or the employer gets a value from you being on call, I'm going to take that argument and I'm going to apply it to workers' comp, and I'm going to say, the minute you log into that app and say, here I am, I'm ready to work, I think that as an employee, you're in, and you should be getting workers' comp benefits.
Does that work for cab drivers also?
Interesting. Cab drivers have a whole nother subspecialty, right? So they're not technically covered under that ride-sharing law, right? Because they've got a medallion.
Right.
And their medallion creates a different set of rights and responsibilities, because that medallion, the medallion is what they actually post on the cab from the old days, right?
Oh,
Where
yeah.
they rivet it onto
Remember
the
that.
hood of the car. It's crazy. And the laws around the cab companies and the independent contractors are a little bit different. And there is a reported decision around cab drivers, and that was really heavily dependent upon the dispatch nature as well as the economic dependency nature of the cab driver upon the dispatch company. And when, in that particular case, what was really relevant was all of the cabbies had to paint their car the same color. All of the cabbies had to report to work at the same time. All of the cabbies had to be available for the dispatcher to say, you're off and going. So it's a little bit different from some of the things we're talking about on the traditional rideshare, or I should say the new rideshare versus the cabbies. So the law's a little bit different. It's a little bit more well-defined for cabbies as well as for livery or limousine drivers. But I think that across the board, when we look at what the state of New Jersey is looking for, they're looking for the inclusion, and the recent drive by the Attorney General for the state of New Jersey on this topic, together with the recent sanctions and penalties that Uber or Lyft had recently covered by underpaying their unemployment and the withholding taxes across many different jurisdictions in the country, I think we're going to fall and get a good decision on this one.
Joe, if I could hit something else on the rideshare stuff, just to circle back for a second. And one of the reasons why that it's really important that if you're injured while driving for Amazon Flex, DoorDash, any of those kind of rideshare programs, you really need to speak to somebody who's had experience handling these cases, and I'll tell you why. Because there's something that's offered to these rideshare drivers called an occupational policy, and sometimes it's called different things depending on which rideshare you're working for. And what it does is, for an extra X amount of dollars a month, the driver, the injured party in this person, is entitled to a significant amount of their medical benefits paid by this particular policy. However, those policies almost always have a clause in them that says if you file a workers' compensation case, the second your attorney hits that button that files with the Department of Labor, that policy is now moot. So I've seen it around, from different firms where they're immediately jumping in to file a claim on behalf of these rideshare drivers without really doing a vetting process to see if they signed up for this occupational policy. Because if you have the ability to get all of your medical bills paid and not have a delay, because most often the insurance companies will deny the case in New Jersey Workers' Compensation Court, saying it's an independent contractor. Now, Adam and I don't buy that, but it still oftentimes, as happening right now, requires litigation. But if your client can get the medical treatment, and they may even have lost wage benefits within that policy as well, you're doing your client a disservice by filing the claim right away, because then that all of a sudden negates the occupational policy. So it's really important, if you ever have somebody from Uber, Lyft, DoorDash, you have to ask them if they ever signed up for this occupational policy. They may have different names, so you got to ask it in different ways. Do you pay X amount of dollars a month for, we asked for additional medical benefits in case you're injured, and you wouldn't believe how many times we've asked. Their initial response is no, but then when you dig a little bit deeper, and they have signed up for it. And it's really, really important that you don't have them lose that benefit, because if you can have your medical bills paid right away and have lost wage benefits paid right away without having to go through litigation, that's the best thing for your client.
And the interesting, Joe, and this is really for your viewers, it's really important that when they evaluate which attorney to hire, you take the information that Justin knows, and you take that qualification that he has as being certified as a specialist in workers' compensation law by the Supreme Court, and you say, who is it that I'm going to go get my advice from? And you look at Liz, who's also a certified civil trial attorney.
Right.
She has got the same type of subject matter expertise on civil trial and Social Security law and the interplay between them. So when your viewers are evaluating who to go to for legal advice, it's really important they find people who have broad areas of knowledge, like Liz does in both civil trial and Social Security, as well as Justin on the workers' comp and civil. I know, Liz, you see this a lot when you do the overlay between personal injury and Social Security, right?
Yeah, definitely. And a lot of times people think that with Social Security that you have to be permanently disabled forever.
Right.
And you don't. As long as you have a disability that lasts at least 12 consecutive months, even if you go back to work full time, you still can maintain a claim for SSD. And a lot of people don't know that, so they may be giving up an opportunity to bring a claim if one is there.
Yeah, it's funny because so many attorneys, right? People who say they go out and they do this for a living and they help injured people, they may not know that nuance. And I know that Liz, clearly as an expert in both areas of law, she's got it. But I'm sure in your practice, you're able to spread that to all the other attorneys in your firm too, right?
No, definitely. And a lot of attorneys call me and ask me questions about disability.
Me being one of them.
me too.
Yeah.
Two of them right here.
Yes.
And they'll call me, or I'll get a client that came in and they're talking about, they've been out of work, years.
Right.
And never thought to even file for Social Security, didn't even know that it was available. And I have others where, they were out a year and a half, didn't know it was available. If they go back to work full time, then we could pursue a closed period for the amount of money that they were out, like for that period of time. There's trial work periods involved, so that if they're out of work and they decide to go back to work, the government will give them a trial work period where you can collect benefits and try to go back to work.
Right.
And if you're successful after 9 months, then your benefits stop. So there's just a lot of different issues, and people don't realize it. So when clients call, and I say, where have you been? Like, that's my first thing, like, where have you been? Because the government will only go back 12 months. Okay. So if somebody's been out 3 years, let's say, because of a accident or whatever, and then they wait to come and see me, and 3 years later, I can only capture back 12 months of that time period.
Wow.
They've lost 2 years of money.
Joe, can you imagine that? Just by not acting, right?
Hold on to that thought. We're going to take a break.
Oh, yeah?
Sure.
Bills, and we right back with these three and myself, and stick around.
Hi, I'm Angela Pipersberg, and I have a new show here on RVN Television called The Angela Pipersberg Show. And I want you to join me every week as I sit with guests and we discuss their life journeys, share wisdom, and tips that will inspire you to live your best life. Don't miss The Angela Pipersberg Show every week here on RVN Television, where we're celebrating life and we're inspiring you to greatness.
Hi, I'm Dr. Esther Malave, and welcome to my show, Achieving a Better You. Through this show, we're going to explore ways to make a better version of you. For example, nutrition, finance, fitness, health. Remember that there's always a way of making a better version of yourself, no matter what the circumstances are. And remember to look for Achieving a Better You show on RVN TV.
Some say the world has never been more divided, more self-centered,
Gosh, thank you so much.
more uncaring,
Thank you. Oh, miss. Thank you.
that we've never been more disconnected. But through our windows, we're able to see so much good every day. And it's clear that a little kindness is never really little.
Did you know that only 8% of people who set their goals, they actually succeed in achieving them? Well, if you want to be a part of that 8%, then you need to tune into Achieve with Wanda Martin, where I will teach you tips, tools, and strategies on how to achieve your goals in any field and on any level. So tune in, watch me on the RVN network on how to achieve your goals and be a part of that 8%.
this edition of Coffee with Joe. I'm Joe Osamendi, your host, but again, that's not the most important thing. What's really the most important thing is these three people right here. Adam Kotlar and Justin Cohen and Elizabeth Berenato. Thank you again for joining me, because I'm really interested in learning more about workman's compensation. And also, let's talk about personal injury too, because they do overlap in a lot of
Sure.
ways, right?
Sure.
But one other thing we should touch on with workman's comp is we talked a little bit about the 1099 thing. And I think a lot of people that are 1099 don't think they're eligible for workman's comp. Is that correct? And yet they can be. Is that right?
Right. So being a 1099 employee does not necessarily mean you're not entitled to workers' compensation benefits. And I would argue even the inverse, that most 1099 employees are entitled to workers' compensation benefits. It usually comes down to the control of the employer over the employee and the economic reliance of the employee upon the employer. So you think of real estate agents who are 1099, I think misclassified actually as 1099s. I think that's one of the paramount cases. And most real estate agents, that's their job, right? They're showing houses in morning, afternoon, nights, weekends, and even though they were classified as 1099s, they were found to be most of them rely upon the employer for their financial well-being, and they're told usually where to go by their employer. Hey, you have to show this house in Cherry Hill, or that house in Voorhees, or this house in Morristown. And so
Sounds like maybe house shopping.
Yeah. I've been through it only for the better part of 2.5 years. But so being a 1099 is certainly not dispositive in workers' comp. And again, the inverse. I think most 1099s usually end up being classified as entitled to New Jersey workers' compensation benefits. So that's probably the most common question that I get from people who are quote unquote independent contractors or 1099. Well, I'm not entitled to benefits, and that is patently false. Most of the time, it ends up being they are entitled to benefits.
Has the landscape changed because of the people working remotely now because of workman's comp?
I think so. I mean, I think when we look at how the employer gets a huge benefit by reducing some of their overhead costs, by not having to have the big offices, by not having to bring everybody into their facility, the employees working from home, created a little bit of a change in the paradigm. And it was interesting, we were talking during the break a little bit about, is it fair to the employer when somebody falls down over their child's toy? Right? They're getting up to answer the courier who's coming to the door to bring them their package of work to be done, and they fall over the kid's toy on the floor. Is that really fair to be a workers' compensation case? And the answer is absolutely, right? If they were at work, if they were at the traditional office, and the same employee fell over a box that a courier left, it's a workers' compensation case. No less so just because the environment where they're working is their own residence. No less so because the risk is the kid's toy rather than the box. Because remember, or learn, that workers' comp is a social legislation. It's a balancing act. We're giving up the right to have open-ended damages. Right? There's a specific schedule that workers' comp applies to what value your objective functional loss turns into dollars. When Liz tries a civil trial case, there's no chart, there's no cap. It's whatever is a jury determines is fair, just, and reasonable. Well, in workers' comp, that ain't the case. In workers' comp, it's you get this much disability based upon this much objective functional loss. And that trade-off, the balance between a limited amount of recovery, which the courts all say is not enough, right? Every single court says workers' comp is at best an incomplete recovery. It is an unclear, not enough to really compensate somebody. But the plus side is that we include everybody, right? We don't want them fighting. It's really deemed a no-fault type statute, where even the employee's own negligence, even if they made a mistake, they tripped over their own feet, they tripped over their own bottle of water or kid's toy, they still get benefits. That's the social trade-off that we were looking at.
Now, when we talk about workman's comp, let's talk a little bit about personal injury now.
Sure.
Because I think there's an overlap there.
Sure.
And also, I guess that's introducing like a third party, isn't it?
Yeah.
Okay.
Always.
Literally, yeah.
So kind of put that together for me.
Sure. Well, when we look at our civil court system, right, we know we've got civil trial work, which is, motor vehicle accident, slip and fall case, nursing home neglect cases, and then we look at the workers' comp claims. Many times there's a direct overlay where we've got somebody taking Uber and Lyft out for a second who's driving for their employee, traditional employment, right? I have an amazing paralegal who's going to run to the post office to deliver something.
Right.
And she or he gets into a car accident. Well, that person's got a workers' compensation claim against the employer, me, as well as a potential third party, meaning an unrelated entity, for the person that hit them, the guy or girl who's driving the car that smashes into the back of them. So there's an interplay between the workers' comp, right, no fault benefits, and then the liability case, the person that hit them. And then we add on top of that, there's also uninsured or underinsured benefits that may come against the individual who's hurt their own insurance. So when we look at this, and I know Liz does this in her practice as a certified civil trial attorney as well, we look at how do we set our clients up for success before they get involved in the accident. And one of the keys is to make sure we evaluate what type of insurance that our clients have purchased.
Okay.
So in the auto insurance category, we look at what not only their liability, how much money their insurance will cover for an accident that they cause, but also what's known as uninsured and underinsured motorist coverage. Now, uninsured is exactly what it sounds like, right? Means the person that caused the accident, the person that hit the guy or girl in the back, has no insurance. So we look to the amount of uninsured coverage that was purchased by our client. And I know Liz has often counseled her clients the same way that we do, which is there's only one right answer. You buy as much as you can afford. Right? So for the primary liability for uninsured motorists, it should be a $500,000 policy. And yeah, it may cost $50 or $75 more per year, but you protect your own assets when you're buying that liability policy that's up here. But on top of that, you've got to buy the underinsured and uninsured so that you match your limits of liability. So if Liz was driving, I don't ever wish bad upon you, but if you were driving,
Don't put that in the air there.
and somebody struck your car and you needed a lawyer, I know you'd go to. I think I know you'd go because you can't represent yourself, right? You definitely follow the Abe Lincoln rule. We look at the insurance that was purchased to see how much uninsured coverage is available, and that's where you want to match it. And again, $50, $100 a year to match the uninsured to your own limits of liability, and that way if you're struck by somebody who doesn't have the financial wherewithal to pay the actual damages, and this isn't workers' comp, right? It's not limited to the schedule of benefits and disability. This is whatever a jury would determine. If you've got the right amount of uninsured and underinsured motorists, you can go after your own insurance company to get full compensation to the extent available. So that's really important. And that's where having a lawyer doesn't mean having a lawyer when you have an accident. That's when having a lawyer means having a trusted counselor that you could call and say, hey, I've got a question. And I know this is the way that we practice in our law firm, and I know that at Bross Frankel, Liz and her team does the same thing, which is we're available. You have a question, there's not a stopwatch on the desk, right? There's nobody going, oh, let me see if I can bill my client a 0.2. We want our clients to call. We want to hear about their family. We want them to ask their questions. And we want to give them good legal advice so that they're prepared in the future. So when they have a problem that comes up, we've taken all the steps with them necessary to help lay the groundwork for success, including a free evaluation of their insurance policy so they can get the right insurance.
Well, this is an extended coffee and show today, but we're going to take the first half here, and we're going to take a break.
Sure.
But I want you guys, one of the two, or anybody, to take a look into that camera and tell people how they can reach you and who should call you.
Sure. Joe, thanks again for having us. Part one. I guess we did well enough to make it back to part two, which is...
I was worried about that.
We beat the odds on that one. Thanks so much again for having me. My name's Justin Cohen. I'm with the firm of Kotlar, Hernandez Cohen. I can be reached at our office number, 856-751-7676, or certainly by email. My first name, Justin, Justin, @khcfirm.com.
Okay, and we're going to be back for part two of this interview with these attorneys, and stick around.
Hi, I'm Angela Pipersberg, and I have a new show here in RVN Television called The Angela Pipersberg Show. And I want you to join me every week as I sit with guests and we discuss their life journeys, share wisdom, and tips that will inspire you to live your best life. Don't miss The Angela Pipersberg Show every week here on RVN Television, where we're celebrating life and we're inspiring you to greatness.
Hi, I'm Dr. Esther Mullave, and welcome to my show, Achieving a Better You. Through this show, we're going to explore ways to make a better version of you. For example, nutrition, finance, fitness, health. Remember that there's always a way of making a better version of yourself, no matter what the circumstances are. And remember to look for Achieving a Better You show on RVN TV.
Some say the world has never been more divided, more self-centered,
Gosh, thank you so much.
more uncaring,
Thank you. Oh, miss. Thank you.
that we've never been more disconnected. But through our windows, we're able to see so much good every day. And it's clear that a little kindness is never really little.
Did you know that only 8% of people who set their goals, they actually succeed in achieving them? Well, if you want to be a part of that 8%, then you need to tune into Achieve with Wanda Martin, where I will teach you tips, tools, and strategies on how to achieve your goals in any field and on any level. So tune in, watch me on the RVN network on how to achieve your goals and be a part of that 8%.
Well, welcome back again to this edition with Coffee with Joe. I'm Joe Osmendi, your host, but once again, that's not the most important thing. The most important thing are these people I have with me, because we're really talking about workman's compensation, we're talking about personal injury, we're just talking about Social Security too, which is another aspect of this entire conversation.
Sure.
And I have Adam Kotlar and Justin Cohen and Elizabeth Berenato, and thank you so much for joining me again.
Thanks for
Thanks for
having
having
us.
us.
Yeah.
It's a pleasure to be here.
Oh, my pleasure. And you know, all these things kind of go together. And then now we even talked about Social Security benefits, right? Which is a totally different area. And your area necessarily isn't in workman's comp, but it's more Social Security, is that right?
Yes, I don't handle, and my firm does not handle any workers' compensation cases.
Okay.
If someone calls and has a workers' comp issue, we refer them to Kotlar, Hernandez and Cohen, Adam and Justin. They're the preeminent firm in the area for
Thank you.
workers' comp. And I know when I send clients there, they're going to be satisfied. They've got a tremendous staff, people who can take calls. They're a larger size firm, but they have a personal touch that is really important to me, because that's the way I handle my clients. So workers' comp, Kotlar, Hernandez and Cohen is where they should go.
Thanks.
That's really kind of you. Thank you.
Yeah.
We're always honored to get the referrals from you and from your team, and we know that you treat your clients like their family.
Yes.
And we follow that same approach. So we're always comfortable knowing that if we've got a client with a Social Security claim, we know what we don't know, and we don't know it.
I had
So-
an education session with Liz on the phone on a Social Security issue, and after that education session, I said, this is exactly why we send all of our Social Security,
right.
because I didn't understand a darn word she was saying, so all I know is if somebody needs a Social Security issue or they've been out of work for an extended period of time, we send it over to Liz and Bross Frankel, so it works both ways.
Let's talk about that for a minute. How do the Social Security benefits work in this situation with personal injury and workman's comp?
Well, first of all, when the client calls in, sometimes they'll call in and just say, been out of work, and I'm looking to file for disability. And when I
Right,
talk
okay.
to the client, I always try to determine what the cause was for them not being able to work any longer. Is it a work injury? Is it a personal injury? Is it a chronic health condition? Because a lot of times embedded in a disability claim is a potential claim for workers' comp or personal injury. And
Okay.
if we don't inquire and get the information from the client, that's our responsibility to do that. So I talk to the client. Social Security is very structured. You have to be out of work 12 continuous months due to a disability, or if your condition is terminal. And it has to be 12 consecutive months. So if you're working a few months and you go back to work and then you're out again, that's not going to work. It has to be 12 consecutive months. After the 12 consecutive months, if it's you feel as though you're able to try to go back to work, you can make a work attempt. And under the government rules, there's work attempts available. If you try to go back to work and you work 9 months, that's considered a successful work attempt. And that 12-month period of time that you were out would be considered essentially a closed period where you would be able to collect the benefits for the 12 months. But let's say you return back to work and you're not able to, you're not able to work, and you go out again. Then that would be an unsuccessful work attempt because you didn't accomplish the full 9 months. And that happens a lot. Even if a client is approved for Social Security, and while they're collecting, if they feel as though they're able to make a work attempt, they're able to do that. The government does not want to penalize people for trying to go back to work. The goal is to get people to go back to work. So you can collect Social Security and go back to work and collect your full salary while you're working. If after 9 months you're able to continue, then Social Security will stop your benefits. If you're not able to continue and you only have a brief period of time where you're back to work and you go out again, that's an unsuccessful work attempt, and they will continue to pay you. So there's a lot of different twists and turns with disability. The other thing is, it doesn't matter why you're injured or why you're unable to work. The cause is not really relevant. So if a person had, a workers' compensation accident and Justin and Adam handled that and they hurt their back, but let's say they've got a chronic condition like diabetes or kidney failure or something like that that's got nothing to do with any kind of claim, that is relevant. If they've been injured in a car accident, had some other area of the body that was injured, that's considered. So basically with Social Security, we just take everything that's wrong with the person, whether it's chronic, traumatic, hereditary, whatever, and put it all into one big pot, and that's your claim. And that's how we pursue it. So we don't have the burden of proof for causation, unlike the workers' comp and PI cases.
Right.
It doesn't matter the etiology.
When I listen to you people, it amazes me how complex this seems. It's not like you just call somebody up and say, I got hurt, can you get me a settlement?
It's true.
And that's why I think people think it takes so long to get some of these settlements. Is that because of the complexity?
Well, with the government, there's a backlog, and there's really no settlement. It's you put the claim in, it goes through a process, and at some point we get the claim approved. Sometimes we have to go in front of a judge. That happens more often than we would really like. But the administrative hearings are very important because that's our trial.
Right, okay.
It's not just a hearing where you go in front of a judge. It's actually, I consider it to be a trial because you're presenting a case in front of a judge, you're presenting medical evidence, you're presenting testimony, you're making legal arguments to try to get your client approved for benefits. So the mechanics of how to get approved are different, but on the back end, the structure of what the person gets paid is established through their work history. So unlike a PI case where, injuries could be any amount of money, or in a workers' compensation case where it's very structured, it's Social Security, it's all predicated on your income and what income you had in the last 15 years. And they come up with a monthly amount, and that's the amount you get. Unless it's supplemental security income where the person doesn't have any work history. Then that's sort of like the government's equivalent to welfare.
Okay.
And you're not able to have certain resources. It's very limited in scope as to what clients would actually qualify for SSI. But basically, the more money you made and the more you work, the more you're going to get on a disability. And it's actually the equivalent of what you would get at full retirement. So, but you don't have to be fully retired to get Social Security.
Joe, I think you hit it right on the head. This is not for the meek, right? Social Security disability is an incredibly nuanced area of the law. And although many people could say, oh, I'm a licensed attorney, I'm legally authorized to do it, that does not mean that they're competent in the law. That doesn't mean that they're strategic in the way that Liz is. And the experience that she brings to the table in figuring out how to maximize the benefit, prepare the case in a way that she's trying it like she tried when she was trying cases in civil court, where she still does, in the Superior Court. I mean, this is an amazing difference for many people, right? You can't just go to somebody who says, I can do it. I think that your audience and the people that listen to Liz speak have to say, wow, she's exactly the kind of attorney I need if I need somebody to represent me for my Social Security case, because it is very nuanced and it is not for the meek. And there is nothing meek about Liz when she comes to being an adversary.
That is for sure. And I'll take it one step further. I think lawyers get in trouble and do a disservice to their clients when they end up trying to dabble in something.
Sure.
I've had a bunch of people say, how hard can it be to file a New Jersey workers' compensation claim or file a dog bite complaint in civil court or an auto accident? And, I get calls, and we're an open door. We're happy to share any of our forms and templates and walk people through things. But that's really where lawyers get in trouble. And I would say you're doing your client a disservice by doing that. Where you really can do your client a service is being able to issue spot. So if a client comes in to me or Adam or any other attorneys in our office with a workers' compensation case, we're doing a disservice to that client by not digging deeper and saying, hey, is there potentially some third-party negligence claim here where maybe we can turn this New Jersey workers' compensation accident, which in a vacuum just looks like a workers' compensation accident, but hey, maybe there's some third-party liability here. Maybe if we dig a little bit deeper, we can find that the general contractor didn't provide a safe environment for the subcontractor, or perhaps the equipment left out was from another subcontractor on the job site. And we can go after that subcontractor for a third-party case. And now take it a step further. Hey, our client suffered a really significant injury. This person has been out or is going to be out for a while. This guy may end up, or this woman may end up on Social Security. Let's get them over to Liz's office. So, a lot of attorneys' instinct are to try and do everything. And, the old saying goes that a jack of all trades is a master of none. Right. And I would say, that is not the right thing to do, but the right thing to do is educate yourself enough where you can issue spot, so then you can know, hey, this looks like a potential Social Security issue. Let's get it out to Bross Frankel. Or this may be a medical malpractice claim, or whatever the legal issue may stem from that accident. That's where you really need to be knowledgeable to be able to issue spot. So it's something that I've seen come across quite a bit, and this is why it's so important that when you're working at a law firm, you have your own law firm, whatever it may be, to develop relationships, because there's people out there who it's your job to make the best experience for your client and present them with the best representation. And if that's not it's, in my opinion, the onus is on you to find them someone who excels at it. That's why it's so important to have relationships in the legal community that you are.
Yeah.
I'm glad you brought that up, because a lot of people think, I have a friend who's an attorney, he can handle this.
Right.
And all of a sudden, that's probably the worst advice.
Right.
Because that's like saying, I'm a carpenter, but I can do brain surgery.
Right. That's exactly. I feel like you probably could, but most people aren't. Let's not try it out, though. Let's not try it out.
But that is so important, because the complexities of some of these issues have got to be with specialists.
Yes.
And if you don't do that, you're a disservice to yourself, first of all. And I think what you mentioned is the responsibility of the attorney and also to get the best possible resources for their clients.
Yeah.
Which I think you guys do on a day-to-day basis.
Absolutely. I mean, look, you've been, not calling you old or but you guys have been practicing a little bit longer than me, but I'm sure there's areas of law where if somebody came in, maybe family law or something like that, you just would not feel comfortable. Right. Even if, thank God, we're blessed that we have a busy practice, but even if we had not, I'm assuming that both you guys, if a client came in with a legal question that was outside the sphere of your expertise, that you probably wouldn't go ahead and handle it.
Yeah, without a doubt. I mean, there's an ethics rule on the topic about the duty of competency, and that sets a very strict obligation for all attorneys in New Jersey. You're not allowed to handle a case if you're not ethically competent to do it, and that's easy. That's great. But then there's another part, right? It's your morality. Right. It's how do you want to be treated? And for us, we treat our clients how we want to be treated. We really believe in following that golden rule. So I don't want to have my client experiment with me figuring out what does this mean, right? I don't want to be there first. I want to have my client and our firm's clients have a great experience, which means putting them in with the right person for the job. And that's not always us, right? Take a criminal law case, I can litigate. I've tried a huge number of cases. Justin can litigate huge number of cases. I will never try a criminal case, right? I don't know it well enough. I don't know the nuances of it, and nor should my clients' safety and freedom and liberty be put into risk because I have a thought that I want a client rather than the right client.
Right.
So New Jersey provides for a couple of areas of specialty. And you can't say you're a specialist in New Jersey in any area of law unless you're deemed board certified by the state of New Jersey, by the Supreme Court of New Jersey. Now, the Supreme Court certifies people as municipal court attorneys, criminal trial attorneys, workers' compensation law attorneys, matrimonial law attorneys, and civil trial attorneys. Those are the 5 areas that people can say they're specialized or they're specialists or experts in. And if you're not certified, you can't advertise, you can't hold yourself out as a specialist. So Liz, I know even though a lot of her practice is in Social Security disability, she's certified as a civil trial attorney. Less than 3% of all attorneys have any certification at all. So she brings with her, on the Social Security context, all of the years of experience of trying jury trials. So when your audience is evaluating those people that should look for a Social Security attorney, look for somebody who's specializing in civil litigation, which is such a strong corollary to Social Security. Because it's not just enough that you're ethically competent to do something, the question is, are you the right attorney for that client? And I think that's really important.
And you're certified in 2 areas, correct?
That makes me certifiably crazy, yes.
It does. I can certify to that.
Which is probably so rare. I wouldn't even speculate as to how few people actually have certifications
4
in 2 areas. So you're certified in workers' compensation, and you're a certified civil trial attorney as well.
Yeah, I think that from my end of it, I know what I like doing. Right? And I like trying the cases, and I know who I like trying them for. Right? I want to represent the injured person, injured at work, injured at the negligence of somebody else. So these became the 2 areas that were my work drive, and I wanted to deliver a great quality representation. So I spent the time, energy, and effort to try enough cases in both civil trial, superior court, jury trials, as well as in workers' comp to do it. But that's the overlay, Joe, that you were talking about, which is how do you look at a client and help them in all of their areas? So for us, it's, we've got 5 board certified comp attorneys in our firm. We've got 3 board certified civil trial attorneys in our firm. And then when we look to refer out, like we do for our Social Security, we want our clients to have a great experience with an attorney who's both competent, ethically, of course, and then really excels, certified, and then for us, who's got the heart? Right? Who's going to treat the client like they're our brothers or sisters? Who's going to really put their needs forward? And that's when we look at people like Liz and say, wow, we could trust that she's going to do a great job. So we use it as a screening tool ourselves too, yeah.
You know what? I had a question about workers' comp. Tell the viewers about reopeners, because I think unlike PI, when you settle the case, you're done.
Yep.
You can't go back and get more. But in workers' comp, it's different, right?
Yeah, you get a second bite at the apple, and Justin's going to hit that.
Yeah, sure. So there's 2 different types of settlements you can get in workers' compensation. One is called a Section 20, because it's under Section 20 of our statute. And basically, the insurance company pays the petitioner, your client, a lump sum of money in exchange for giving up all future rights in the case. So if you settle your case under Section 20, you get a lump sum payment within 60 days of the settlement. Boom, you're done. You cannot come back and file what's called a reopener claim for that particular accident. Now, if you get injured again, of course, you can file a new claim and start it all over. But for that particular date of accident, with that particular employee, your rights are over. Then there's something called an order approving settlement, and that's kind of what Liz was hitting on. Now, you do get a second bite of the apple if you settle your case under an order approving settlement. Effectively, you get assigned a disability rating. And that disability rating is something negotiated between your attorney and the attorneys for the insurance company. And of course, the higher the disability rating for that particular body part, the more money that gets paid out over a number of weeks to your client. Now, the rule in New Jersey is that you have 2 years from the date of your last benefit to reopen the case in the event your condition worsens. And what is defined as a benefit? Typically, what we tell our clients is mark the date you get your last check, and it's 2 years from that date. Okay. Now, very rarely, sometimes somebody may go for a doctor's appointment, or maybe a pain management appointment, or a physical therapy appointment, whatever it may be in that interim, and then the clock would start all over. You'd have 2 years from that date. But to be safe, and what I always told my clients when we were physically going to court, and most things are remote now, but what we tell them over the phone is, it's better to be safe than sorry. Mark 2 years from the date that we settle your case, from the time the judge puts his stamp on that order. and put that as the starting point for your 2-year period. Because why risk it? Because we don't get notice of when they get their last check. And listen, if you're like me and you're a little bit disorganized with your mail and you have stuff all over your house, you may not know when your last check was. So use the date of the date of the settlement, the date that the judge put his John Hancock or her John Hancock on that order as the 2-year period. And then what happens is if your condition worsens, you call your attorney, they file a very simple reopener application, and then you request the insurance company to send you back to the treating doctor. And oftentimes that ends up in additional treatment, and you may get more treatment, and you can get another disability rating award, maybe an increase in the percentage. Or if you haven't, perhaps that may be a right time where then you negotiate a Section 20, so you're getting your client some additional money in exchange for closing out the claim. So that's, as far as I know, I don't know any other states personally that have that right. There may be some, but I know the states that we see oftentimes, like Pennsylvania, does not have that right. So although the payouts in workers' compensation are structured and they're scheduled on that chart, one of the kind of quid pro quos is that if your injury is sufficient, you're going to be able to reopen your case in the future. So that's one of the the nice aspects of the statute. So I hope that explains it. Yeah.
One of the things that I'm interested in pursuing is that can a PI case be open-ended? I mean, how long can it last? Is there any kind of limitation?
There's no limitations other than the fact that the court will schedule, once you're in litigation, you'll have called discovery end dates. So the court will assign a date, depending on the type of case it is, where all of your discovery, your depositions, your written discovery, your production of documents have to be done. And then after that time, there'll be a mandatory arbitration. That's non-binding, but it's a mandatory arbitration. And after that point, if you're still not able to resolve the case, then the court will set it for trial. Now, that can keep getting kicked down the road, depending on the nature, depending on the backlog of the court, depending on what type of case is, like a medical malpractice case versus your standard auto case, or perhaps even a commercial litigation case versus an auto case. So the timeline can depend, but there are deadlines, but oftentimes they're a little bit flexible. So there is no particular date or time that your case is going to have to resolve by, but there are at least deadlines that are a little bit flexible.
And in the workers' comp world, it's a very different area, right? Workers' comp benefits are not structured to end at a certain time. If somebody gets permanently and totally disabled through a work-related accident, they get benefits for their entire life. So it's a little bit different. Justin did a great job on the civil stuff, but in workers' comp, it's lifetime. You can have a case if you're unfortunately injured at a very early age, and if you are determined to be totally and permanently disabled, your benefits last until you die. Or your dependency benefits can last for that same duration. So a dependency claim would be if somebody passed away from work and their spouse was economically dependent on the person that passed away. The spouse, the man or the woman, it's not sexist, it's very gender neutral, the man or the woman who's surviving spouse can establish a lifetime claim for dependency benefits for as long as the surviving spouse lives. So there is no fixed end on a permanent total disability case in workers' compensation, which is an interesting nuance in the law too, unlike in civil trial world.
This is fascinating because there's so many different aspects of this whole thing that people I don't think understand.
Sure.
Just because they're not lawyers, they're in unfamiliar territory.
Right.
But I do think that both you gentlemen, Liz, I think that you really look out for your clients, and the first thing is you do everything to make sure that they get what's rightfully theirs.
Absolutely.
And that's the most important thing. So I love about having you guys on my show.
Thank you.
Because that's really, it's so important to feel somebody you know, like, and trust.
Sure.
When you're dealing with something like a permanent injury.
Right.
Injury.
Well, I know and trust him. I don't necessarily like him.
Yeah.
But,
feelings 100% mutual. We spend a lot of time together.
Yeah, too much time, some may say.
I feel a lot better when I get out of here if I trip over something. I'm not worried about a damn thing.
I love it.
We'd much rather you never get hurt, so quite honestly.
Yes.
And the truth is, for all of our clients, although we're always appreciative that they have the confidence to come to us, and we're always honored when we get the referral from an attorney for their injured person to have us help them. I'd rather our clients never have the injury, right? And especially the ones that are more significant, right? Our hearts go out. We could never make them whole. We could never undo the damage that was done. And so for so many people, we would much rather, in a good way, never meet them. In a good way, never have them suffer the harm that they've suffered. In a good way, never have to fight for them to get as best we can to compensate them.
Liz, why don't you take the opportunity now to look in that camera and tell people how they can reach you if they have some Social Security questions.
Absolutely. I'm Elizabeth Berenato with the law firm of Bross Frankel in Cherry Hill, and you can reach us at 856-795-8880. Thank you, Joe.
Thank you, folks. I think it's been a very enlightening, expanded version of Coffee with Joe. Something I know I'm very interested in. I'm sure a lot of my viewers didn't know some of the things they could be, let's say, compensated for.
Sure.
In case they have to. Picking the right lawyer is important. Understanding the complexities, as we talked about, something like that, so that you get what you're entitled to. That's the bottom line. And,
Absolutely.
again, thank you guys for being here.
Thanks for
So
having
thanks
us.
for having us.
Appreciate
Liz,
it.
it's always good to hear
Yes.
from you.
Thank you.
And
Thanks, guys.
thank you for joining me in Coffee with Joe. I'll see you next week. And if you need any kind of area of expertise with workman's comp or personal injury or Social Security, this is the place to go. No question about it. Thanks again.